SwayamPrabha. Digital India. Educated India.
Hello friends, we are discussing the law relating to women and children in the present session under this course. I have come up with the topic protection of women under labor laws. Why the women are to be protected under labor laws? This is very significant question relating to this topic. To go further in details of this topic, it is important to note that under Article 14 of Indian Constitution, the discrimination cannot be made on the basis of sex. It means that women and men, they should be treated equally in all the walks of life. In earlier lectures, we have seen that what is the position of law relating to the status of women, relating to the protection of women in different aspects of their life. Everybody is entitled to right to work. Men and women, irrespective of their sex, they should be given the opportunity to contribute in the national progress and national development. It is very important to give the sufficient and adequate opportunity to the women to work in different employments, to work in different fields. But it is also the fact that when the women work out of the family, they have to balance their role within the family. It has been the traditional concept, it has been the traditional belief, it has been the traditional practice. It has been the traditional duty of the women also to take care of the family and children. It is not only the social responsibility of the women to take care of their children, to take care of their family, but it is also personal responsibility of the women because of some biological and because of some sentimental status of women. Women, they always give the priority to take care of their children, and only after having the satisfaction that they are fulfilling their duties towards the children and family, they decide to work. In this backdrop or in this context, it becomes necessary to protect the women or to give the sufficient protection to the women in the field of labor law. For this purpose, different facilities have been provided to the women. Under the Constitution also, the provisions have been made for the equal pay and equal work, for the fair conditions of the work for women and men both. And as the women are different from biological aspects, from their physical, with respect to their physical capabilities, they cannot work in such a manner in which a man can work. This is a reality, and this reality has to be accepted by the policy makers, by the lawmakers also. Article 14 of Indian Constitution provides for the regime of equality. It is the unique feature of our Constitution and also of the concept of equality in Indian Constitution that we did not adopt the concept of absolute equality as it was pointed out or proposed by Dicey under the meaning of rule of law, whereas in India the modified meaning of equality was adopted with the concept of reasonable classification, because it was thought, it was realized that equal treatment with equals guarantees the equality, but if the unequal treatment is made with equals, then it further results into inequality. The men and women, they have their own inequalities, and therefore, the men and women cannot be treated in equal sense with respect to labor laws also. Some protections, some facilities are to be provided, have to be provided to the women, so that they can avail their right to work equally with men. And from this point of view, because of this reason or this concept of equality, in India different facilities, different protections have been provided to women. Under labor law, we see that the women are entitled for maternity benefit. It is not only the legislative initiative, it has also been provided in the constitution itself that the women should be given the benefit of maternity relief, so that they can fulfill their family responsibilities and the responsibilities, their responsibilities towards their children. One more aspect where the positive or affirmative discrimination is made to the women working in factories or some employments, it has been directed that laws have been made that crèche facilities should be provided by the employers, so that the women without any pressure can devote their time properly in their work. In this context, it is important to see that what protections are being provided under the labor law to women, and therefore, this topic has been chosen, the protection of women under labor law, for the discussion as the 12th lecture under the course of law relating to women and children. Friends, as per the census of 2011, the total number of female workers in India is 149.8 million, and female workers in rural and urban areas are 121.8 and 28.0 million respectively. In the rural areas 121.8 and in urban areas 28.0 million female workers are there. Although the census reports over the last 1 century shows a gradual increase in the rate of female labor force participation, the conditions under which they work still are largely exploitative. We see that if we see the different earlier census, it shows that there is continuous consistent increase in the female labor force participation, meaning thereby the number of women worker, the number of female workers in different employments is continuously increasing. Though the number of female workers, female employees is continuously increasing, but it seems that the conditions under which they work are exploitative, and such a reform or such improvement could not be made with regard to the conditions of service or the conditions of labor for the women. There are constitutional safeguards and other legal measures to protect the women interest or the interest of women workers in our country. The second National Commission on Labour has also justified the protective discriminatory legislation in favor of women by recommending that all such legislations are necessary for women workers. The second National Commission on Labour has justified the protective discriminatory legislation this protective discriminatory legislation can be enacted by or protective discriminatory measures can be adopted by the state, by the government under article 15 clause 3 of Indian Constitution. And therefore, the commission suggests that the state should come forward, the state should come out with the protective discriminatory measures by recommending that all such legislations are necessary for women workers, otherwise the women workers cannot compete with the men workers, the female workers cannot compete with the male workers properly. While there are multiple statutes aimed only at women, such as the Sexual Harassment at Workplaces Act 2013, Maternity Benefit Act, etc., such legislations have been made as the protective discriminatory measures in favor of women. A number of other statutes have special provisions for the welfare of women workers. These are the general legislations which are also connected with the labor law, but the specific legislations have also been made providing for the provisions for the welfare of women workers under the labor law regime. One important aspect as to the protection of women under the labor law is the maternity benefit. The Maternity Benefit Act 1961 provides for following benefits. If we see the provisions of Maternity Benefit Act, it provides for certain benefits to the women. This enactment was made in 1961 to protect the women workers against any kind of discrimination on the basis of sex, against any kind of discrimination because of their inherent inequality with men at the workplaces, and therefore, it was thought that some benefit should be provided to women so that they can fulfill their family and social responsibility also at the same time when they are working in different employments. This Maternity Benefit Act prohibits knowingly employment of women in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage or medical termination of pregnancy. This is section 4 subsection 1. So, section 4 subsection 1 of the act prohibits knowingly employment, yani that means no employer can employ a woman in any establishment during the 6 weeks immediately following the date of her delivery, miscarriage or medical termination of pregnancy. So, if there is any instance of the delivery or the miscarriage or the medical termination of pregnancy with a woman, then it is the duty of the employers that they cannot employ them after following the 6 months from the date of such delivery, from the date of such miscarriage, from the date of such medical termination. Section 4 subsection 2 also prohibits that women shall not work in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage or medical termination of pregnancy. So, two-fold provisions have been imposed. The section 4 subsection 1 imposes the provision on the employers that they shall not employ any woman in any establishment, in any employment immediately following the day of her delivery, 6 weeks immediately following the day of her delivery, miscarriage or the termination of pregnancy. On the other hand, the women are also prohibited to work in any establishment during the 6 weeks immediately following the day of her delivery. Now, there may be the doubt or a confusion may arise, a doubt may arise in our minds that it is correct that employers are prohibited to employ the women in any establishment. But if a woman willingly wants or wishes to work in any establishment during this period, then why the provision has been made on the women? It is not correct situation, and this is unreasonable restriction over the right to work of a woman. But we also know the fact that the employers can compel the women to work during this period, and whether they are working with their free consent, with their own decision, with their own determination, or they are working because of the compulsions being made, indirectly being made by the employers. This cannot be examined, or this cannot be determined, and therefore, the women are also prohibited to work during this period in any establishment under subsection 2. Under section 5, subsection 1, every woman shall be entitled to and her employer shall be liable for the payment of maternity benefit at the rate of the average daily wage for the period of her actual absence, that is to say, the period immediately preceding the day of her delivery, the actual day of her delivery, and any period immediately following that day. Now, see that if there is any instance of the delivery of a woman and she is the employee in any establishment or in any employment, then this is the duty of the employer. The woman is entitled to the payment of maternity benefits at the rate of the average daily wage for the period of her actual absence, and the employer is liable for paying such maternity benefit to the woman. No woman shall be entitled to maternity benefit unless she has actually worked in an establishment of the employer for a period of not less than 80 days in the 12 months immediately preceding the date of her expected delivery. This is one restriction which is imposed on the maternity benefit to be paid or to be received, to be paid to or to be received by the woman under subsection 1 of section 5. The restriction is that if the woman wants to receive the maternity benefit from the employer, from the establishment, then it is the condition that she has to work minimum for 80 days in the preceding year. In the year preceding to her delivery, she had to work for 80 days, minimum 80 days, only then she is entitled or she can take the benefit of maternity relief. The Maternity Benefit Act 1961 entitles eligible women employees, the women employees who are eligible for the maternity benefits, eligible who are eligible for maternity benefits, who under subsection 2 of section 5, the condition has been imposed that preceding the year of her delivery, she had worked for at least 80 days. If she is eligible for maternity benefit, then under the Maternity Benefit Act 1961, the women employees is entitled up to 26 weeks of paid maternity leave. Section 5 subsection 3 provides for the maternity leave of 26 weeks, and this maternity leave is the paid leave. For that period, the establishment or the employer has to pay full salary, full remuneration to the woman for 26 weeks. Up to 12 weeks of paid maternity leave to surrogate mothers and to women who adopt a child below 3 months of age. It is also very interesting provision, it is also very dynamic provision in the Maternity Benefit Act, that maternity benefit is not confined, it is not available only to the women who give the natural birth to the children or child. Those women are also entitled to maternity benefit who are the surrogate mothers, who are the commissioning mothers, or the mothers who adopted the child below the age of 3 months, if any woman has adopted a child below the age of 3 months, she is entitled for the 12 weeks maternity relief. If any woman is acting as surrogate mother, she is surrogate mother, then she is entitled for one distinction is made in these two conditions. The 26-week paid maternity relief is given to the general women who give birth to their own child, and if any woman employee is the surrogate mother, if any woman employee is the adoptive mother of a child below 3 years, then she is entitled for 12-week maternity benefit. Women employees are eligible to paid leave in case of illness arising out of pregnancy or delivery, premature birth, miscarriage and medical termination of pregnancy. Not only for birth, but the women employees are eligible to paid leave in case of illness arising out of pregnancy. If any woman is or becomes ill arising out of pregnancy, she is entitled for paid leave. If she becomes ill because of the delivery, because of the premature birth, because of the miscarriage or because of the medical termination of pregnancy, then also she is entitled for the paid leave. The Act provides protection for women on maternity leave from termination of employment and prejudicial changes to their conditions of employment. Why this Maternity Benefit Act is important or significant for the protection of women under the labor laws? Because they are protected against any kind of termination of employment. If the maternity benefit, maternity leave is not guaranteed or it is not given or it is not provided, then there may be the termination of the employment of the women if they are continuously absent from their services, from their place of work. There may be the changes to their conditions of employment or conditions of service. The employer can change the conditions of service, and therefore, for giving the protection to women for against any such kind of termination or against any such kind of change in their conditions of service, the maternity benefit plays a significant role. Employers are also required to provide benefits enabling women to return to work after the maternity break, such as providing crèche facilities. Now, after giving the birth, the another responsibility comes to the women employees or women workers. They are to take care of their small ones or small children, and this is very natural connection or natural connectivity between mother and the child. The mother cannot leave the child unattended. She cannot leave the child where there is no provision for care, there is no possibility of the proper care of her child, particularly in today's social scenario where the nuclear families have become the rule. It is important that such arrangement should be made by the employers for the women, so that they can work at their workplaces without any kind of worries about their small children. So, the crèche facilities, nursing breaks are important for the women workers. Employers may also allow the women employees to work from home post the period of maternity benefits, if the nature of the work is such that she may work from home. This is also very revolutionary provision in the Maternity Benefit Act, that the women, they are entitled to do the work from their home if the nature of the work is that it can be done from the home. Then the employer may provide for this facility to the women to assist them to work and to take care of their children. Then the next important enactment is the Employees State Insurance Act 1948. This provides benefits to insured women employees, including medical care, sickness benefits, maternity benefits, and disablement benefits. Now, the maternity benefit have been provided, maternity benefits have been provided in the Act. How the payment of maternity benefit is to be made? The payment of maternity benefit in certain cases. Every woman employee shall be entitled to the payment of maternity benefit under this Act, who is employed in the factory or other establishment to which the provisions of the Employees State Insurance Act 1948 and who fulfills the conditions of 80 days work in last 12 months. So, in the establishment to which the provisions of Employees State Insurance Act 1948 are applicable and the woman who fulfills the conditions of 80 days work in last 12 months, then section 5b provides for the payment of the benefit to such woman. If a woman entitled to maternity benefit or any other amount under this Act dies before receiving such maternity benefit or amount, there may be the condition that the woman, the worker or the woman employee is entitled for maternity benefit, but before receiving the payment of such maternity benefit she dies. Then, or where the employer is liable for maternity benefit, the employer shall pay such benefit or amount to the person nominated by the woman in the notice given under section 6, and in case there is no such nominee, to her legal representatives. Section 7 provides for this condition, that if she dies before receiving the payment of maternity benefit, then such maternity benefit shall be paid to the nominee of the woman, and if the nominee is not there, then to her legal representatives, so that the benefit of the maternity benefit of that woman can be ensured. Every woman under section 8, it is provided that every woman entitled to maternity benefit under this Act shall also be entitled to receive from her employer a medical bonus of 1000 rupees if no prenatal confinement and postnatal care is provided for the employer free of charge. So, there are two things and the employer can opt any one of these. Either he is to provide for the prenatal confinement and postnatal care free of charge, or the employer is to pay the bonus of 1000 rupees under section 8. Under section 9, in case of marriage, miscarriage or medical termination of pregnancy, a woman shall, on production of such proof that there was the incidence of miscarriage or there was the medical termination of pregnancy, may be prescribed, as may be prescribed if such a proof has been produced by the woman, she is entitled to leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage, as the case may be, her medical termination or pregnancy. Now, the second aspect, these were the maternity benefits for the woman and the mode of the payment of those maternity benefits. Then the second important aspect of the life of the women workers is the proper place for the proper care of their small children. This is very big challenge in the life of the women workers or the women employed in different establishments or the employments. They are always worried about their small children who are at home, and therefore, they cannot devote their full capability or their full strength in the work, which goes to the negation of the development of that employment industry or the development of the nation itself, and therefore, it becomes important that such facilities should be provided to the women, so that they can keep their children at the care centers and they can freely work at their workplaces. So, crèche facility for women employees, it also one significant aspect under the labor law. In different legislations the provisions for crèche facility have been provided. For example, under section 48 of Factories Act 1948, it has been provided that in every factory wherein more than 30 women workers are ordinarily employed, there shall be provided and maintained a suitable room or rooms for the use of children under the age of 6 years for such women. This mandate has been given to the employer by way of section 48 of Factories Act, that if there is any factory wherein more than 30 women workers are there, with this condition that if in that factory more than 30 women workers are working, then this is the responsibility of that factory. This is the responsibility or the duty of the employer or that factory management, that factory management shall provide for the room or the rooms for the crèche facility or for the children of women, where the children of women who are under the 6 years can be kept or can be cared. Such rooms, further condition has been imposed, that it is not sufficient for the employers that they are providing the room or the rooms for the crèche facility, but certain conditions have been imposed that what facilities should be given by the employers in that room or those rooms which have been identified for the purpose of crèche facility or for the purpose of keeping the children of women workers under 6 years. What are these conditions? Such rooms shall provide adequate accommodation, shall be adequately lighted and ventilated. Sufficient place or sufficient accommodatory requirements must be there, sufficient accommodation must be there, sufficient place must be there, sufficient facilities must be there, shall be adequately lighted and ventilated. That rooms must not be very closed rooms, unairy rooms, whereas it is required that the rooms must be ventilated, the rooms must be lighted, and these rooms must be maintained in a clean and sanitary conditions. Shall be under the charge of women trained in the care of children and infants. So, all the aspects which are important or significant for the care of children, that sufficient clean and ventilated lighted rooms should be there, with the facility, accommodatory facilities, and not only this, the trained women in charge must be appointed for these creches or for these care centers being established by the factories having more than 30 women employees. Under section 48 of the Factories Act, this requirement has been made, but this is limited only to the organized sector. There was the problem for unorganized sector, there was no requirement of crèche facility, and therefore, there was the discrimination to the women working in unorganized sector. Rajiv Gandhi National Crèche Scheme was introduced. The scheme is aimed at providing day care to the children from 6 months to 6 years of working women. The scheme provides day care with the resting, relaxing and sleeping facilities to the children. Then the Weedy and Cigar Workers Act 1966, it also requires every industrial premise having more than 30 female employees to provide and maintain crèche facility to the children under the age of 6 years of such female employees. Such crèche facility should provide sufficient and adequately lighted, ventilated and maintained accommodation in clean and hygienic conditions. These care facilities are required to run under the charge of such women who are educated and skilled in care of children and infants. The similar provision has been made in the Weedy and Cigar Workers Act 1966. Then one more enactment was made in this regard, one more provision was made for the requirement of the crèche facility, Interstate Migrant Workmen Act 1979. It is most significant requirement for the women workers who are migrants. The women workers who are residing at one place and work, they may arrange for their children to be cared for, but the women workers who are the migrant workers, the certain place is not identified for their stay, they are in more problem, and therefore, the Interstate Migrant Workmen Act 1979 provides for the provision of the requirement of creche facility. The contractor or principal employer of every establishment with 20 or more migrant workmen is obliged to provide creche facility for their children under the age of 6 years. In now you can see the distinction, point of distinction in earlier two enactments making the requirement of creche facility and the requirement being made in this enactment, and you can understand the more severe problem of the migrant women workers. In earlier two provisions, in earlier two enactments, the condition was of 30 women employers, whereas in Interstate Migrant Workmen Act 1979, the establishment with 20 or more migrant workers, these establishments obliged to provide creche facility for their children under the age of 6 years. This creche must have at least one play room and one sleeping room, along with sufficient number of toys and games in playrooms and cots and beddings in the sleeping room. Further expansion of the requirements or the clarification of the requirements has been made in this act, that all the required facilities for the care and development of a child should be made by the employers, by the establishment. The creche is required to be capable of giving adequate protection against heat, damp, wind, rain, and providing sufficient ventilation and lighting. It is also required that such creche facility must be situated from a convenient distance from the establishment and must have supply of drinking water in sufficient quantity. Then the Building and Other Construction Workers Act 1996 and Plantation Labour Act 1951 also provide for the creche facility for children under the age of 6 years with adequate and sufficient accommodation, ventilation, lighting and sanitation. There is one more enactment which provides for the creche facilities, the Mines Creche Rules 1966. Under the Mines Act, the Mines Creche Rules 1966 have been enacted. Under these rules, this is an example of detailed set of rules on standards of creche, the standards which we are seeing, which are set out in the piecemeal manner in different enactments. In the Mines Creche Rules, these standards have been enacted in very details. These rules provide for the requirements as to the construction of the rooms, what kind of construction, what quality of construction should be there of the rooms in a creche, exposure to air, floor covering should also be child friendly, hygiene and toilets for children. Rules prescribe the requirement of standards as to the staff, medical facilities and diet of children, because the nutrition is also one important aspect with regard to the care and development of children. The rules also necessitates the opening of creche during the working hours of women workers irrespective of the timings. So, if the establishment provides for the different spans of the duration, different durations of the working of women, then for all those spans or durations of working, the creche facility should be opened. We were talking about the Rajiv Gandhi National Creche Scheme. I told you that in different enactments, the provisions for creche facilities were made, but these all the provisions or these creche facilities were available only to the women workers working in organized sector. There was the problem for the women working in unorganized sector, and therefore, the Rajiv Gandhi Creche scheme was introduced to include also the problem of the women workers in unorganized sectors. The scheme is aimed at providing daycare to the children from 6 months to 6 years, daycare with the resting, relaxing and sleeping facilities. It includes the early motivation and encouragement to the children below 3 years and pre-primary education to the children of 3 to 6 years. Now, if we look at the childhood care, education and development, generally the age of the childhood has been specified in India, elsewhere also, from 0 to 6 years, and this period of 0 to 6 year of a child is very prominent period for the further progress of the child. All the foundation of future learning is laid during this period, and therefore, to prepare the children for pre-primary education is the big challenge during this age. This is also one requirement, or this is also one justification for which the crèche facility must be provided to the children of women worker, because the women workers cannot devote the sufficient time to their children, quality time in quality and time in quantity to their children for their better development, and the children of any nation or the future asset of that nation, they are the future human resource of a nation. The development of the country is also dependent of the factor that how the children are being prepared for their future learning, and therefore, this early childhood, the span or the duration of early childhood care and education, or the life of the early childhood care and education, that is 0 to 6 years, is divided into two parts, 0 to 3 and 3 to 6. Because these are the two periods of the life of the children or life of a child, where two different approaches are required to prepare, to care or to educate the children. 0 to 3 years age, it is the age of motivation, this is the age of encouragement. 0 to 3 years age, the children are to be cared for in such a manner, so that they can be motivated, they can be encouraged and they can be prepared for the pre-primary education. When the children go directly to the primary education, they are not able to take the burden of the further education, and therefore, to prepare them for primary education, to orient with the primary education is also one significant aspect of the education and development of small children. So, the crèche facility must include these two initiatives, the encouragement, motivation and encouragement to the children below 3 years and pre-primary education to the children of 3 to 6 years. Supplementary nutrition is also a challenge in the country like India, where we see that there are the several cases, millions of the children, they are malnourished, the proper nutrition is not being provided to the children, and particularly this problem is with the working mothers, that they are not in position to provide the proper nutrition to the children during their working time, and therefore, the crèche facility must be equipped with such requirement also. So, supplementary nutrition, monitoring of the growth and proper health checkups and immunization of the young children of working women is also one important aspect. It has been provided in the Rajiv Gandhi crèche scheme, that crèche under the scheme shall be open for 26 days in a month and for 7.5 hours per day. The maximum number of children in a crèche shall be 25. Nominal charges in the form of fee are charged under the scheme. Fund share system has also been developed for the proper effectuation of the scheme. Under system, the union government, state government, union territories and non-governmental organization, voluntary organizations shall share the fund in the ratio of 60-30 to 10. For northeastern states and Himalayan state, it is 80:10:10. For union territories, it is 90:0:10. The responsibility of union territories goes with the union government, and therefore, the share of union territories is 0, it is being expended by the union government itself. The crèche facility promotes gender equality and gender diversity at workplaces and helps the women employees to manage and balance the care of their children with the responsibility to work. So, it is very important for the protection of the right to equality of women or for ensuring the gender equality at workplaces to provide for such facility to the children of women. But one important point is also is to be pointed out, that such crèche facilities available only for children of women employed in certain specific establishments. The children of women working in an organized sector are not entitled to the benefits of such statutory crèche facilities. In this context, the Rajiv Gandhi National Crèche Scheme for the children of working mothers deserves appreciation, no doubt, that it also includes the women workers from unorganized sectors. But the scheme makes the provision for participation of 50% of children from poor families who are below poverty line, but the payment of fee is required also for the children from BPL families. So, this is the contradictory provision. At least 50% children should be from the families who are below poverty line, or these are the children of those women workers who are below poverty line, but the fee has also been imposed, though there is a distinction in the fee to be paid by the working mothers from BPL families and working mothers who do not belong to the BPL families. But even though the prescription of the fee is a big issue, because the provision for payment of fee may be, because this is the responsibility of the state to take care of the children of working mothers, and this early childhood care and education should be taken as the responsibility by the government, by the state, and therefore, it may be submitted that the provision for payment of fee may be reconsidered for the reason that health, protection, care and education of early childhood should be the responsibility of the state. Then one more enactment with regard to the protection of women under labor law is the Equal Remuneration Act. For the equal remuneration, there are certain international conventions or international law. ILO Convention on Equal Remuneration, the issue of equal pay for equal workers goes unchampioned even by trade unions, as they often do not view this to be a problem that affects the workers as a whole. Trade unions have also not been very much cautious about this concept of equal pay for equal work. The majority of active female workforce is involved in the informal sector, such as agriculture, domestic work, which have very few regulations in terms of remuneration and social security. And therefore, the ILO Convention on Equal Remuneration 1951 recognizes the principle of equal pay for equal work. This is the origin point of the concept of equal pay for equal work or equal pay for the work of equal value. Promotion of equality in employment is positive enforcement. This involves breaking down both horizontal and vertical occupational segregation, and therefore, ILO Convention is very important with regard to the implementation of the equal pay for equal work. This ILO, the spirit of ILO Convention can also be seen, can also be found in Indian Constitution. Indian Constitution also provides for the equal pay for equal work. If we refer to Article 39 of our Constitution, it directs that states shall in particular have policies towards securing equal pay for equal work for both men and women. This is also one important constitutional mandate for ensuring the gender equality in the area of labor law. Then in 1976, the Indian legislature enacted the Equal Remuneration Act 1976. Employers shall pay equal pay to man and woman who perform the same or even similar work. Under section 4, this obligation has been imposed over the employers that they shall pay the equal pay for the equal work. Not only for the equal work, they are to pay equally for the equal work and also even for the similar work. No employer shall reduce the rate of remuneration of any worker for the purpose of complying with the requirement of equal pay. Very important, because when the equal pay for equal work or the Equal Remuneration Act 1976 was passed, then there was a challenge, there was a problem, that employers could reduce the pay of the male counterparts for giving the equal pay for equal work, and therefore, this condition has been imposed by section 4, that no employer shall reduce the rate of remuneration of any worker for the purpose of complying with the requirement of equal pay. Employers could not legally discriminate between men and women in the recruitment process unless there is a legal limit to the employment of females in certain sectors. So, they cannot escape from employing the women, they have to employ the women workers also. Employers are required to maintain records and registers related to the compliance and make them available for inspection by the relevant authorities, and therefore, they are duty bound, they are obliged to pay equally to the men and women for equal work. This is section 5. Under section 8, every employer shall maintain such register and other documents in relation to the workers employed by him as may be prescribed. Health, safety and welfare, this is also one important aspect of relating to the women working in different sectors. The Factories Act 1948 mandates employers to take necessary health, safety and welfare measures for women employees. These includes providing separate washrooms for women employees, changing rooms and lockers for women employees, special security and other protocols to engage female employees during night times. It prohibits employment of women in any part of the factory for pressing cotton in which a cotton opener is at work, section 27. It provides employment of women in any factory to lift, carry or move any load so heavy as to be likely to cause her injury. State may prohibit or restrict the employment of women in any manufacturing process or operation carried on in a factory exposes any person employed in it to a serious risk of bodily injury, poisoning or disease, section 87. So, these safety measures have been adopted under the Factories Act. Health and safety of women has been cared for under this act. There are certain restrictions on the employment of women, so that the women cannot be employed in such avocations or in such employments which are not suited or which are not appropriate to their physical or biological state. The Factories Act 1948 restricts employment of women in factories by way of section 66. It restricts employment of women in factories that no woman shall be required or allowed to work in any factory except between the hours of 6 am to 7 pm. This time has been fixed. The state government may vary the above limits, but so that no such variation shall authorize the employment of any woman between the hours of 10 pm and 5 am. So, employment the government can vary the limits of the time, but it cannot authorize the employment of any woman between the hours of 10 pm to 5 am. That means that the duty at the night or working at the night is not the employee cannot the employer cannot compel the woman to work at the night. There shall be no change of shifts except after a weekly holiday or any other holiday. When the shifts are maintained, there shall not be any change in the shifts. The state government may exempt the restrictions in fish curing or fish canning factories, where the employment of women beyond the hours is necessary to prevent damage to or deterioration in any raw material. So, such restrictions may be exempted, but the health safety measures for the safety measures for the health of women, the safety measures for the security of women should be taken into consideration whenever the state government makes any changes regarding these restrictions. So, we can see that under labor law the sufficient protection has been provided to the women for to ensure the gender bias, to protect their right to equality, and if these measures are adopted into spirit, the women workers may be protected very well. Thank you very much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said, but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I will be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samara. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samara and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samara to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet.